Hello, everyone. My name is Salvatore Di Costanzo, and I'm an elder law and estate planning attorney here in Westchester County with offices in Yorktown Heights and Rye, New York. And it's good to be able to host another chat session today, like we've been doing for the last few weeks. And they've been very successful. We've got a lot of people calling, a lot of people asking questions after the fact. Many people watch these videos after they've been posted to our Facebook page, which is planned today for tomorrow. And so I think they're really working out well for everyone. I'd like to wish all of the mothers out there a happy Mother's Day. That's Sunday, and it's obviously an unusual Mother's Day. And not only is it an unusual Mother's Day because of what's going on in the world right now, but it's going to be cold, I think. So usually on Mother's Day, we plant gardens and flowers, and maybe you can still do that, but it might be a little chilly. But I hope everybody that is a mother out there has a very happy and blessed Mother's Day, and enjoy yourself if you can. I also, again, want to thank all of our first responders, our essential workers, all of our physicians, and especially the nurses. I think yesterday might have been National Nurse Day or National Caregivers Day. They deserve a tremendous amount of respect and gratitude. And from the bottom of my heart, I want to thank you for what you've done for people in my family and for everybody else out there. So today we're going to talk about a specific topic. We're going to move away from a lot of the general things that we've been talking about, but you're free to ask questions on anything that you want. Today we want to talk about the Medicaid Trust, which is an asset protection planning technique that ordinarily we're doing Medicaid Trust on a very regular basis. It usually starts out with a discussion about your long-term care needs. And so what I say to people on a regular basis is, can we agree that we may get sick someday? And clearly the answer to that is yes. And if we get sick someday, is it possible that you might end up in a nursing home? And the answer is obviously yes. I don't want to get into a dialogue as to whether you think you're going to go into a nursing home or not. I get a lot of clients that come in and they fight me on that one, and they say, my kids are never going to let me go to a nursing home. And you know, there's the bumper sticker out there that I always get reminded of that says, be kind to your kids, they choose your nursing home. And so, you know, I've gotten into some heated battles with some of my elderly clients that ultimately I have to give up because I might get hit over the head with a bottle of wine or a tomato thrown at me. But the reality is that you could get sick and you could end up in a nursing home. There are a lot of ways you can end up in a nursing home against your own fruition. And it's really something that unfortunately is out of your control. I joke around with clients when sometimes they come in and I shake their hand and I say, I hope you drop dead of a heart attack. And they look at me like, you know, I just met this guy. What the hell is he saying to me? He's telling me to drop dead of a heart attack. And I said, no, you don't get it. You know, I really do hope that you drop dead of a heart attack because, you know, sometimes what you have to contemplate as far as long-term care needs go, it's not pretty. And so the goal here is to be able to answer truthfully to those questions. And then the third question is, well, if that happens to you, how are you going to pay for your care? How are you going to pay for your nursing home care? And it could also be home care, right? How will you pay for that? And that's the genesis for wanting to do the planning that we're about to talk about. And so what I say to people is, you only have there are very limited ways to pay for your long-term care needs. The first one would be privately paying. So you're free to pay for your own care. Most people have a pretty good understanding of what it costs to be in a nursing home, but you're talking about, you know, $15,000 a month in many of the nursing homes in the area. You know, that's a lot of money over the course of a year, and they say the average stay in a nursing home could be 2 to 3 years. I've had clients that have been in nursing homes for, 2 months, 2 days, and I've had clients that have been in nursing homes for 10 years. It really depends. So you really, if you fall into the category of having to privately pay for your care, you could really exhaust or significantly deplete your resources. So that's option one. Option two is long-term care insurance. Now, long-term care insurance could be a good option. You should explore it. But there are a lot of reasons why you may not have long-term care insurance. You may be too old for long-term care insurance. You may have medical conditions that, from an underwriting perspective, they're not going to give it to you. You may not be able to afford the premiums. That's the big one, right? A lot of people don't have long-term care insurance because it's too expensive. And all of these factors might turn long-term care insurance away from you. But it's an option that you should explore. Because if you have it, it's a safety net. And there's all different kinds of products out there. And I'm not going to get into those different types of products. You should consult with a financial advisor or somebody that specializes in long-term care insurance. And I've got colleagues that I work with that I could refer you to. The third option is Medicare. Medicare, this is somewhat of a misconception. Medicare only pays for maybe 100 days in your nursing home. Won't pay for more than 100 days. So you might be in a nursing home and you might get kicked off of Medicaid on day 50, right? Medicare. You're going to get a letter from the nursing home that says, we plan to discharge you on this date. What they mean is that they plan Medicare is not going to pay after that particular date. And then you'll be private pay. So even though Medicare is an option, it's not a good option because after 100 days, you're off, you're on your own. And the last option is Medicaid. So the four options are private, long-term care insurance, Medicare, and Medicaid. And Medicaid is what has become the insurance of the middle class today. Most people don't fall into any of those categories. You don't want to be privately paying for your care. You probably don't have long-term care insurance. Medicare is not a great solution. What's left? What's left is Medicaid. So it's important for everybody to understand why we're talking about Medicaid. A lot of people don't understand what Medicaid actually brings to the table. People think Medicaid is for the poor. Well, Medicaid is for the middle class, and it's one of the few ways that you could pay for your long-term care. Now, I believe that might be a question.
There is a question, so I just have to do the see more. Is it likely that someone will be getting an inheritance after being accepted for Medicaid? Can the inheritance flow into Medicaid trust without jeopardizing the Medicaid status in terms of both income and asset restrictions? Can the flow occur seamlessly, or does the inheritance sit with the individual for a period of time before going into the Medicaid trust? If the answer here is complicated, are there simpler solutions that can be explored?
Well, so that's a really good question, and it's a little bit of a complicated question, but let me see if I can try to give you some guidance on that. You started the question by saying if somebody is on Medicaid. So let's assume for a moment that somebody is on Medicaid in a nursing home setting, right? And everything is going well, right? Their income, when you're on Medicaid in a nursing home setting, your income goes to the nursing home. You're allowed to have some reserves, but not much. But generally speaking, you were found to be eligible for Medicaid because you have less than the Medicaid asset limit, and Medicaid's paying for your nursing home. And now somebody drafted a will, somebody has an estate that now dies and leaves this person assets. If that happens, planning needs to be done to protect some of those assets. It's a little bit too complicated for this chat that we're doing right now, but if somebody receives a windfall, there's a way that we can protect and preserve about 45% of that money. If they're in a nursing home, they're going to lose some of that money. They're going to lose about 50 to 55% of that money. But there are planning techniques that we can implement that preserves about 45% of that money. The real problem with that is that whoever died should be, and this goes for everybody that's listening here, you should not be leaving assets to, seniors that might be of equal generation, older. You have to contemplate that if you leave assets to an elderly person, they may need care someday, and those assets may be subject to the care needs that they have in a nursing home setting. One of the ways around that is to put a special needs trust in your last will and testament. When we draft our documents, even a basic will in my office contains a special needs trust. It pretty much says, I leave my assets to A, B, and C. But if anybody happens to be disabled at the time of my death and at the time that they're to receive these assets, don't give these assets to those individuals outright. Set up a special needs trust. And that's how we protect and preserve assets from going to somebody in a situation where they might be in a nursing home. And even home care, right? So home care presents the same problem. They just changed the home care rules. And they now are going to be imposing a 2.5-year look-back period on home care eligibility, home care Medicaid. That starts October 1st. So we're going to have the same issue for home care purposes in not too long of a period of time. Just a few months ago, if this would have happened to somebody in a home care setting on Medicaid, we would have just taken the assets in the month that they were received and transferred them out. There would have been no penalty period. There would have been no disqualification for Medicaid benefits. But now we've got a new rule, and people are going to start hearing about this, and it's going to cause a problem in a home care setting, and we're going to have to deal with this. So make sure your estate plan is properly drafted. This is an example of why, when people come to us and they say, I don't have much, I just have a basic estate. Why can't I draft my will myself or get it off the internet or go to a local general practitioner attorney? This is a great example as to why you can't do that. So I hope I answered that question. If I didn't answer your question, email me and we could talk more. Are there any more questions?
No, just
Okay.
people are watching.
So let's talk now about how we can preserve your assets in advance of needing care, right? Because we know that we don't want to be in a situation where we have to spend our assets and spend them down. We may not be able to get long-term care insurance. We know Medicare is not the greatest option. So what's left? Medicaid. So how could we set up our estates so that we might be able to apply for Medicaid someday? And the answer is through using trust. I am going to refer to the trust as a Medicaid trust. It is an irrevocable trust. Don't get scared when I say that. A lot of people get scared, they turn white. It's an irrevocable trust, but we're going to talk through some of the salient provisions of this irrevocable trust. It's different than a revocable trust. And the reason why I call it a Medicaid trust is because I don't want to confuse you. I don't want you to hear me say revocable or irrevocable and you can't remember what I said, or maybe my Italian accent doesn't come out too well and things get mixed up. So we're not talking about revocable trust today, but I often refer to revocable trust and Medicaid trust. Today we're talking about Medicaid trust. Now, what does a Medicaid trust look like? Well, before I talk to you about what it looks like, let's talk about when you should be thinking about it. So we really start drafting Medicaid trusts for people in their 60s, let's say. We do a lot of them for people in their 60s, 70s, a good number in their 80s, and depending on the facts and circumstances, maybe even in your 90s, but we have to see. Depends. There is a 5-year look-back period. When you set up this Medicaid trust, there's a 5-year look-back period from the time that you transfer your assets to the trust. So a lot of people want to set these trusts up to protect their house. The house is usually the largest asset, and people are concerned about protecting the house. If we were to set up one of these Medicaid trusts today, and transfer your house to the trust, 5 years has to go by. After the 5 years has elapsed, that's what we call the look-back period, that house can no longer be looked at by Medicaid. Medicaid can't force you to sell it. They can't put a lien against it. They can't do anything with that house. That's something that's very important for you to understand. It's not a 7-year look-back period. It's not a 10-year look-back period. I hear that all the time, and I don't know where people get that from. There's nothing out there that talks about a 7-year look-back period versus a 10-year look-back period. It's 5 years. There's a question.
There is. So again, Christopher's asking, can the sort of planning, wills, establishing trusts, or similar estate planning be done across state lines?
No. So, Christopher, I want to be very clear. Everything that I'm talking about today is New York specific. Every state administers the Medicaid program a little bit differently. Some states don't recognize Medicaid trust. There are different planning techniques that we use in New York that you can't use, for instance, like in New Jersey. In New York State, a qualified plan like an IRA is an exempt resource. If you have a $500,000 IRA, Medicaid will not touch that IRA so long as you're taking the required minimum distributions, which we know that the Secure Act changed the date that you have to start taking required minimum distributions to 72. Connecticut doesn't have that rule. So if you go over to Connecticut, IRAs are available resources. So we draft these documents here in New York under New York State specific laws, and we have language in our documents that allow you to change the situs of the trust to another state. But if you're going to move to another state like Florida or wherever, we advise you to sit with an attorney in that state to review the documents. If you know that you're going to be moving or retiring to Florida, we might work with a Floridian attorney in advance to put the homestead exemption language into the trust and do other things that might make our trust work for both Florida and New York purposes. But that's when we know for sure that there's an opportunity to move to another state. So back to the Medicaid trust. Let's talk about what this trust looks like. It's a piece of paper. It's somewhat similar in language to your will, but it's different. By the way, it's a trust, and since it's a trust, it avoids probate. So one of the benefits of a Medicaid trust, aside from the Medicaid planning, is that whatever you put into this trust doesn't have to go through probate. So when you're talking about legal fees and what it costs to do this, not only are we possibly protecting your assets, but we're also saving you all the probate costs that would transpire upon death to probate a will. Usually you would appoint a child as your trustee. So you might appoint one or two children as your trustees. You might have a niece or a nephew. It's not going to be your spouse, right? We don't appoint spouses, and it can't be you. You can't serve as trustee. So usually it's a child that serves as trustee. And we also don't want to have many people serving as trustee because it's an administrative burden. It's nice to have just one person serving as trustee. The trust provides that during your lifetime, you have the right to receive income from the trust. So a lot of people, and I've written a bunch of articles on this, a lot of people are scared about the concept of an irrevocable trust. A lot of people are scared of giving the house away to a trustee, right? This is my house. This is my house that I lived in for 30, 40 years, and now you're telling me to take the house and put it into a trust where I have no control. Let's talk about that. Those are the important issues. My job today is to try to not only explain the planning technique, but try to distill the fears that you may have, because ultimately what you're going to see is this planning technique is one of the best planning techniques and one of the only planning techniques that you can implement in advance. So the trust provides that you are entitled to the income. So you might put brokerage account assets into the trust in addition to your house. let's say you put a couple $100,000 of brokerage account assets into the trust, and it generates $10,000 a year in interest and dividends. You get that. That comes back to you. What the trust does not allow you to do is it does not allow you to take back that principal, the $300,000 that you put in. You're putting that in there. You're putting that away for the kids. You can't just go there and take it whenever you want it, and the trustees can't just give that to you. There are ways that the trustees can take money out of the trust. If the trust is drafted properly, we can have them take money out of the trust, give it to themselves, and then they can give it back to you. Once it's their money, they can do whatever they want with it. So there are these indirect ways to get money out of the trust. If there's a house, you have the right to live there. Nobody can kick you out. I know that's a big concern. People hear stories all the time about they transferred their house to their kids and they got kicked out. Well, that's because all they did was literally give the house to their kids. They didn't set up a trust. There are stories out there. Those are the bad stories. But they didn't do it right. If you just take your house and give it to your kids, that's the worst thing in the world that you can do. So many people have come into my office and they've said, Sal, I went to an attorney because I said I wanted to protect my house, and they said, well, we have to get it out of your name. That's not the answer. The answer is not to get it out of your name and just give it to your kids. Because sure, then your kids own it, and they can kick you out. The answer is to put it into a trust where we still have a certain degree of control over this trust, and your children are trustees, they're fiduciaries. They have to act in your best interest. So continuing on some of the bells and whistles of the trust, you could remove the trustees and replace them at any time. So let's say you put your two kids in as trustees and one of them becomes a derelict or a spendthrift or whatever. We can exercise documents, we could sign documents removing that child as a trustee. And you can put somebody else in. When you die, the trust terminates and generally would probably pass to your kids. I could even give you a power in the trust to change the beneficiaries of the trust. So that way if you want to move it from one, let's say somebody's going through a divorce or somebody has a spending habit, we can exercise your powers to change the beneficiaries of the trust. So you still get the income from the trust. You still have the right to use and occupy the house. Nobody can kick you out. The house can still be sold, by the way, but it's going to be sold by the trustees, but they can't sell it without your consent. So they still can't throw you out. They still can't sell the house without you. So you get the income, you get to live in the house, it could still be sold. There's ways to still get money out of the trust. You could change the trustees, you could change the beneficiaries. What's left that bothers you? And that's somewhat a rhetorical question, because when people come in here and they say, I don't know, I'm scared, most of the items that I just discussed about this trust should distill any misconceptions you have about the trust and should really put your fears at ease that you're giving away your assets. You're doing it in a very organized fashion. The mechanics behind this really should make you feel comfortable, but it's got to be done right. I've seen a lot of trusts drafted by non-elder law attorneys or people that say they're elder law attorneys, but they don't do this every day, and the trust gets messed up in a lot of different ways. There's a lot of little nuances that we have to be careful about. Ultimately, and here's something that's going to drive you crazy, and it's probably going to confuse the bejesus out of you, but under New York State law, you can actually revoke an irrevocable trust. So put that in your pipe and smoke it for a while. I know that's probably confusing, but if the trust is drafted properly, there's a way for us to play with the beneficiaries of the trust and get those beneficiaries to consent to the revocation of the trust. So let's say you do this and a year from now you're at your monthly Mahjong meeting with your friends and you're hanging out and somebody says, you should have never did that. And you believe that person because for some reason I didn't give you the confidence that you need. And you call me up and you say, after you say a lot of bad words to me, you say, I don't want this trust anymore. What can we do? Well, if we get the consent of the beneficiaries, we can revoke it. Now, very rarely do I have to revoke one of these trusts. It's usually because somebody gets sick during the 5-year look-back period and has to go into a nursing home. Because if that happens, we've got to reverse it, and we've got to kind of go back to the starting grounds. So it's a very useful planning technique. This is what we do. This is our planning technique of the day. It's our bread and butter of an elder law practice. We do a lot of these Medicaid trusts. If you don't do something like this, if you don't do a Medicaid trust, you're back to that quadrant that I discussed before. How are you going to pay for your care? If you don't do the trust to try to become eligible for Medicaid someday, you're left with privately paying long-term care insurance or Medicare. And you're going to find that private pay is really where you're going to end up. Those are the horror stories. Those are the stories that you hear from people where they have to sell their property. You know, your primary residence is afforded certain protections because it's your primary residence. But Medicaid can still put a lien against it if it's not in a trust. And for any of you that own property outside of New York State, maybe you have a vacation home, that's not your primary residence. So immediately upon needing nursing home care, you're going to have to sell one of those properties because you're just not eligible. But with a Medicaid trust, we can put those properties into a Medicaid trust and they're off the table. And this is how people are passing wealth from generation to generation. I have a story that when I say that, it reminds me of this client that I had. I was in a nursing home and meeting with my client who had done the Medicaid trust. And she was sitting in the hallway next to somebody that was a pretty prominent business owner in the area. And he owned a bunch of different pizzeria restaurants, but he never did his planning. So he was sitting in the nursing home, and one by one they were selling restaurants or doing whatever they needed to do to monetize the assets of the restaurant so they could pay for his care. And my client had a good amount of assets in a trust, and Medicaid was paying for her care. So this is real. This is real. And this is an excellent planning technique. I've got plenty of articles and blogs that I've written on my website about Medicaid Trust. You could visit my website at Plan Today for Tomorrow. If you'd like to email me, my email address is smd@mfd-law.com. If you like these video conferences, then please share them with your friends. There are so many people out there that are watching these a couple of days later, weeks later, and you might be listening to this and say, wow, my parents should be doing this. My mom and dad, we've been talking about this for years. It's about time. And it really is about time. You don't want to be that family that doesn't do this planning. And finally, if you want to call us, the phone number is 914-925-1010. I don't think there are any more questions.
Not at the moment.
But feel free to email me. And again, I hope everybody stays well, stays healthy, and happy Mother's Day to the mothers out there. Take care.